All right, welcome back. We are at General Housing and Military Affairs, and we are continuing work on the proposed amendment to the eviction moratorium. We got to a certain point this morning, but we were interrupted by technical difficulties, and I want to pick up work on it. Basically, we're trying to work through a section, renovation of section 4. And where we left off was in section G, and Representative Walz had made a statement. I don't know, Representative Walz, if you could restate that statement, your concern with section G, and then Representative Murphy was just about to make a response to that before we went off the air.
Yeah, technology, I love it. And I was a technology coordinator for the Berry Supervisor Union when I retired, and believe me, I sympathize with the folks who are providing tech support right now. They've got the job cut out for them. Yes, the point I was making, we changed G. I think the original language in G was appropriate because it did encompass any kind of issue which could cause irreparable harm. And that was including a specific issue that we talked about earlier. If the owner of the building had an agreement to sell it, but that agreement could not go forward because of a tenant issue. I believe the original language in G resolved that issue because it dealt with irreparable harm. And when we changed it to deal specifically with property, it took that element away. So I would propose that we revert to the original language. And I think D and G as written address both property issues, health issues, safety issues, and any other kind of issue we can't think of. I think it's better to be broad and inclusive rather than narrow and exclusive. Thank you.
Thank you, Representative Walz. And I just want to share that I do appreciate we have the same end in mind. I think that certainly the intention of my language changes to G are that it is even more inclusive. It does not restrict it to property. It adds the word property to the language because otherwise it just speaks to damage to the applicant or other residents. It doesn't actually speak to the property. So it was an or, again, changing that word and that it was immediate or irreparable injury in line G, and then loss or damage, not sure exactly of the wording, but of property or to the applicant or other residents. So it was a list of where the damage or loss or injury could be rather than restricting it to property.
Okay, and I may have misunderstood that. I understood that the word applicant had been removed and replaced with property.
No, it was just adding it to the list. That's, yeah, I got it, that was where your concern lay. And so I appreciated that you were supportive of my intent. and I think that with David on board, we can make sure that's what the language is, if that's the will of the committee. But it was just a proposal I was adding. And I think that one of the bigger issues for others may be removing the word and, so that the injury, loss, or damage can be immediate rather than having to prove it as irreparable. But you are speaking within an emergency context. So I think that there's still a critical level that has to be met.
Mhm.
So can you see the screen?
Yes.
So we're talking about these two words here. Tommy, are you satisfied that those words are as long as applicants in there, that we can keep that proposal in there?
Yes, I thank you. Thank you for that clarification. I was concerned that we were limiting ourselves to property, and that's not the case. So that's good. Thank you.
Okay. With that settled on there were, I believe, at least a couple of more points that people wanted to make. I believe Representative Pulaski, you had said that you really wanted smoke detectors in the health and safety.
I did. I realize there are other things in there that specify safety and things like that, but I just think having the part about smoke detectors and it's disabling the smoke detectors themselves, it puts a little bit more emphasis on that issue itself. And that's a proven fact. Smoke detectors not working properly, being disabled or not there at all, have been attributed with the fact of people dying in fires. And I'm not making that up, and I'm not a fireman. That's a fact. It's been proven, and I just think it's really important to put a little extra emphasis on that in here. I think somebody mentioned earlier some of these laws and things like that are what people read, and if they see it in front of them, maybe, just maybe, it puts a little bit more emphasis on it. Hey, if it saves one life, it's worth 1,000 words. So, I just really wanted it in there.
So that would be in section D.
Yeah, I gotta plug it in yes or something. Hang on just a second.
Chair, would it work if we said something like, for example, in D, or including the?
Or such
I think including is always the first choice because it stands for including but not limited to. Thoughts, committee?
I guess I'd be fine if we just add at the end of the D, including disabling of smoke and carbon monoxide detecting devices.
Well, there's two factors here. There's smoking in violation of the no smoking policy on rental units, which I'm pretty sure most everybody has. Again, it gives emphasis, and furthermore, the intentional disabling of a smoke detector so that you can get away with smoking in violation of the policy. Not saying everybody does it, but I do know for a fact that there are lots of people that do it.
So John, I'm sorry, I don't have the other document available. So are we talking about, let me reshare the screen here. Sorry.
Okay.
So you're talking about right here in this area?
I gotta flip back to yours. Hang on just a second, sir. Okay, yes. So D, if it said after the word or including, either one is fine, but including smoking in violation of a no smoking policy and or maybe perhaps, I'm not an English major, but and or the disabling of smoke detectors. Keeping it simple, as we used to call it in the Army. But again, people see it, they read it. If it's in front of them, it has hopefully a little bit more emphasis. I'm just trying to save lives here, and that's as far as I'm going to go on that one.
And if anybody has language that they want to throw out while I'm typing, here we are.
I would say disabling or removal of smoke detection devices.
I think the smoking inside might actually be covered under the damage to the property already in that, and if it's against your lease as well.
And as well as the, damage to the smoke detector is probably covered as well. Again, I'm trying to make emphasis here. So again,
Right, but this, I think,
including,
the health and safety, I mean, you can make an argument, of course, about secondhand smoke and all that, in terms of residents, but I think in terms of, I mean, what is in a public safety sense, I'm just saying, throwing this out here as I look at this, that in a public safety sense, that disabling the smoke and carbon dioxide detectors you can argue that that's a public safety issue more
And
so
Chair
than somebody
Stevens?
personally smoking.
Chair
I'm not-
Stevens, I think the language that's commonly used, certainly when you hear the little thing on the airplane, is tampering with.
And if I may say, it's carbon monoxide, not carbon dioxide.
Of course it is. Yes, thank you.
My pleasure.
and I'm not talking, guys, I'm not talking about secondhand smoke here. I'm talking about smoking in violation of the smoking policy. That's got nothing to do with secondhand smoke. Smoking
No, I understand that. I'm
in
just,
violation of the smoking policy and/or if you want to use tampering and it's, whatever, I don't really care as long as it says something. Tampering with smoke and carbon monoxide detectors. But we're not getting the smoking in violation of the policy. That's not even in there yet.
I would, Chair, may I just speak to that point, or are we in a queue here?
there may be a queue, but I'm not, again, I can't see it easily.
I was
So-
just going to offer that I think that there's a difference in emergency and severity between tampering with the devices that protect a facility, a building, and someone smoking a cigarette, even if they're smoking in bed, God forbid that, that still occurs. But I think that, again, we have to remember we're looking at emergency cessation and action. And I'm not sure that violating a smoking policy beyond the fact that, if you've disabled the detector so it doesn't go off, that's what can be caught for that emergency level. I just would offer that.
And I would counter that respectfully, being that if you're smoking in bed, that's a pretty good reason to have a fire.
Oh, I know. That's why I
You need
said,
fire
God
to-
forbid.
You need fire to need the smoke detector. So, I don't know. I just,
All right, I do,
Or like, how about like the disabling of like, fire safety equipment, independent or hardwired? Because you can also, do we want to cite the fact that multi-units have to be hardwired? I don't know if that's too much language or not.
I-
No, we don't do that.
for something that's temporary.
No, okay.
I have Representative Parsons, then, and then Byron, if you want to stay on the list, and then Triana.
I think I'm good. Sorry. I made my point.
Legacy hand is calling you now. Okay. So Matt, did you have a further comment?
No, I mean, I totally support the intent of the Representative Plasic's comments in trying to move this. I think it's important to recognize that people will do those things. And it is a highly dangerous scenario for all other occupants of the building. So I completely support the intent of this. And I'm just trying to wrap my head around where the conversation kind of landed us right now. So that's what I'm doing, but I appreciate moving forward with it.
Representative Triana.
Thank you, Chair Stevens. So I'm okay with the language around disabling smoke and carbon monoxide detectors. I am absolutely opposed to making smoking in your own apartment a cause for eviction. That is just not severe enough. I'm with Barbara. That is just not severe enough to facilitate an exception to evictions. And people who smoke in their own apartment do not need to be evicted from their apartment and ultimately become homeless. Thank you.
Representative Walsh.
Thank you. I agree in essence what Representative Troiano said. I think, if you have no smoking in the lease, that's a violation of the lease. just as if you had no pets. I think that's a different kind of issue to be dealing with, and it doesn't have a place in this bill. I don't think we're talking about lease violations as emergency, leading to emergency eviction procedures. Thank you.
All right, so we're kind of split on this. So I think I've heard that everyone supports tampering with smoke and carbon monoxide detectors. And we're split on the smoking within the apartment. So I would just, Representative Bloomley?
Yeah, I just would say that, I mean, it may be okay with the landlord for somebody to smoke in the apartment. That would be part of the lease. So I guess I don't think it's important to put in here. It doesn't have the same impact that Representative Plasek was seeking, and maybe irrelevant in certain leases. So.
Representative Byron.
No, I just want to echo that same thing. I wholeheartedly agree with the issue surrounding the tampering with the detectors and whatnot. But should someone be violating, under this emergency provision, I am not supportive of making just merely smoking cigarettes or anything else a violation of these terms for the eviction moratorium. I think that's something that needs to be viewed at within the lease structure itself as a less severe violation.
Representative Hango, then Plasek.
I believe Representative Byron just voiced my opinion on the language. So I'm also in agreement as long as the tampering with the devices is in there. Thank you.
Representative Plasek.
Okay, just to be clear, I never said that I expected somebody to be evicted because they were smoking in the apartment. What I did say is I was trying to get emphasis on this as a safety issue and put it in there. Now, it also would have to be in violation of the policy. So what another representative just barely said, if the landlord says he has no objections if you're smoking, then that's not in violation of the rental lease agreement, I guess you call it. But, and if you really think a judge is going to evict somebody for smoking in the apartment, I really don't think that's going to happen either. So I am obviously concerned about the wording of that, but I am much more concerned about the, now we're using the word tampering, of the smoke detectors. And I really do think that is something that is very, very important. So just trying to clarify what I'm saying. You're not going to get evicted for smoking in your apartment.
Okay.
And I think the word tamper is important because you can tamper and not disable.
Yep.
Like tamper leads to disabling. So I think yes.
No, tampering is a good term. But you could, I don't know. I never tampered with a smoke detector, but I guess you could probably put a piece of tape over it or something to keep anything going up in there to cause it to alert. But I don't know. But that's, again, tampering is a good word. Because tampering,
Shower caps work well.
Tampering is a good word. It can be anything from trying to keep it from working to totally removing it. So that's a good word. And again, I'm only trying to save lives here.
Mhm.
That's my sole intent here, is to save lives by adding the extra part about the smoking in there for emphasis purposes. Thank you.
No, thank you, Representative. Representative Murphy, then Triano.
Thank you. I think it came clear to me that the issue we're looking at is we are looking to exemptions from the moratorium on eviction. So we are looking for what would permit someone to request an eviction. And I think that's the part where I don't believe that the smoking fits in this correction that we're making today. And I certainly support the thought that it is within any landlord tenant relationship, that if you've got an agreement that there's no smoking in your building, then being caught smoking is actually is a reason to say you're in violation of our lease. And I have to say that there was kind of a quip made earlier in some testimony earlier today about even marijuana smoking. And if you're in an apartment that in any way is subsidized by federal monies, or a building that accepts federal monies, you better not be smoking marijuana at all. So I think that those all have their place and are covered, but not necessary for this piece we're working on.
Representative Toronto.
Yes, Barbara covered a lot of what I was going to say. If we list smoking in the exemptions to the eviction moratorium, then actually that a person could possibly be evicted for smoking in their own apartment. That's the point, John. I mean, that can be if it's added to this list of exemptions. Barbara's right. Your landlord can. It was in the legalization bill. The landlord or employer can prohibit anyone from smoking weed in their apartment or house. So that's true. But that's already in the law in the marijuana legalization bill, or the law that we passed.
Representative Plasek.
And somebody could also be subject to a not to exceed fee of $5,000 as an administrative fee for a failure to pay a $35 rental registration. I mean, it doesn't mean you're going to get that. And there's no way a board, commissioner, or a judge would order anything like that, no more than he would evict you for smoking in your apartment. At least that would be my assumption anyway. But again, that's right now it's a play on words. But I think maybe at least I'm not happy with it, but at least the tampering helps. And my thing is only trying to save lives. But thank you.
Representative Kalaki.
Thank you, Chair. I think I don't know if I'm the last one to speak on this or not in our committee, but I am yes for the disabling the smoke detectors and no on adding the smoking language. So I think we've pretty much heard from everybody. I'm not sure. So could I make a motion that is what we would consider?
For that section?
Yeah, for that,
Yes.
that one section.
It sounds like to me that we've reached a consensus. I don't think we need to have a vote. Is that, that's what I'm hearing, is that,
Yes.
Even with people upset or not satisfied, we've reached a consensus. So
Yes.
we'll leave section D there, adding, so let me come back to the share screen. So right here, this is the information that we added. Right, so we're saying we can move on from here. Thank you. And Representative Plasek, I do understand your concerns, and you've made them clear. I'm hoping that as a compromise language, I hope this is sufficient in our work. This may not have been the hardest piece in the bill, but I think, the reason we needed to talk about this separately was for these very reasons. It's tough to come together in the same spot on this. Did anyone else have overt questions? I don't have notes that show overt questions. I have one about, and the reason I asked, we asked David to be here because he's our counsel, but also capital letter E, I had just thrown in the as defined in XXX. I had asked David to kind of look at this and determine, is there better language that gets at, I think we know what we want from a landlord or landlord's immediate family. But the definition that you can find online for HUD's definition of family is very broad. And I had asked David to see if he could find any information or any language that was more precise than, a cross-reference to HUD's 37-page definition of family. So David, are you here?
I am here.
Do you want me to put this up? Do you want me to put this up on the screen, or do you have something you can share?
No, go ahead, please.
So we're talking about that language there.
Yes. So, I mean, I guess I was under the impression that you all were going to continue sort of fleshing out who you wanted to include, as you referenced, Mr. Chair. So there's the HUD definition 24 CFR 5403. It is pretty big. I mean, it includes, but is not limited to, regardless of sexual orientation, gender identity, or marital status, a single person, or a group of persons residing together, which includes a family with or without children, an elderly family, a near elderly family, a disabled family, a displaced family, and the remaining member of a tenant family. And all of those in turn are actually defined in terms of their own in the federal regulation. So there's lots and lots of groupings there. And I guess the real question is, who do you want? I mean, are we just talking about, and there are just so many examples in statutes of where we draw those lines about who is or maintains a household, related persons, immediate family members. Are we talking about just when you guys are saying landlord's immediate family? I guess I want to know, how far does your circle extend in the way that you've been thinking about it? Because I haven't heard any of this discussion.
Well, we haven't had it today.
Not since today, huh?
We haven't had it today, but we have, it's been in the document, but we've been talking about some of the other issues. Because in one hand, to me, this is a choice of, what you're asking for direction is the choice between, the limitation in the family. And what we meant by that, again, the HUD definition is really quite broad. So let's spend a little bit of time right now, committee, and I'm gonna stop sharing for the time being and weigh in on this. I have Representative Murphy, then Byron. And Kalaki, John, did you have your hand up? So I think Representative Kalaki was up first.
I do too.
Thank you. David, I am comfortable that if we can align it with a broad statement that aligns with the HUD definition of the broadest definition of family. I think that's, if it's a collective of people who choose to live together and they want to buy a property and they are a family, they're a self-defined family, that seems as appropriate as a married couple to me and their children. So
Yeah, here's the only issue I see is that if we're talking about two propositions, the landlord, his or her, their self needs to move back into the property. That's one thing. Then we're talking about a group of people that does not include the landlord, but has some sort of a relationship to the landlord. And if you're talking about that B proposition, then we need to, if we don't link it to some sort of relationship to the landlord, then it literally could be anybody.
Right.
Like another tenant.
No, right. I thought it was landlord or immediate family.
Well, that's how you have it written right now, but I think under other constructs that, and there's also the question of what do we mean by immediate family? Do you just mean parents and children, step-parents, stepchildren, brothers, sisters? What about grandkids, grandparents?
Right. We had a very long conversation about this last year on paid family leave, for instance, about, you know, just about how we accounted for who you could take care of. But again, in this particular case, for these purposes, what we've heard, I think what we've all heard is that it's the focus of this has been the idea that a landlord could not get, or landlord's family members could not get back into the house that they owned. So, which is a differently, it's pretty narrow. But again, committee, Representative Murphy, you had your hand up next.
Thank you, Chair Stevens. Yeah, I really believe, again, we have to remember the context we're looking at this in, and it's an exemption to the moratorium. And so I would go with the sense of this being a narrow interpretation of family member. And hope we have something already in one of our statutes that speaks to parents, children, grandchildren, steps, of course, because they're part of your family. But you know, I was hoping David might be able, and you referenced it a little bit by saying, or the chair did, that there was a conversation a couple of years ago to determine a ranking of whose family. I think that the instance and the use of this, again, because this is all hopefully going to not be an issue in not too distant a time. I don't know if maybe just saying immediate family and leaving it to a judge to determine.
May I share my screen and show you an example of how our statutes would define immediate family member?
Please.
I hear you, Representative Murphy. And there are, like I said, a lot of
Oh Lord,
these instances, but here, this is in Title 8. I'll let you read it. So again, that may be broader. These people are identified at, in their relationship to the landlord. The presumption is they would be living there without the landlord. And the question becomes, is this the right, circle, or is this too big, too narrow?
yeah, I think that as I was sharing my position, this would be broader than I had in mind for this emergency situation. But I hate to restrict what someone thinks is family to them. And that's the challenge.
Representative Byron Ganhango.
Thank you. I had sort of the same approach that Representative Murphy had. In my mind, I actually, in my head and on paper, I started writing down what was kind of turning into this list as I was trying to link what immediate family would be without getting to sort of the cousin nucleus, I guess. And this is a little bit more extensive, but I completely understand why it applies. And I think that's becoming a little too robust for what we're trying to do here. I mean, I almost think it might have to be directly linked to the individuals who are title holders to that property. Since we're talking about a moratorium that exists within this session law. Because I kind of feel like there's no like in the middle, right? I mean, I guess we can do it in the
Well,
middle.
there's
But
not.
when do we start trimming?
Yeah, no, there's not an in the middle. I mean, but again, this is, if we're going to use the word family, then this is what, you know, many times we work on expanding the definition of what family means because the definition of family changes. And I mean, this is the first time I've ever seen language that, I mean, and this isn't from a banking and insurance statute. So this is the first time I've seen reference to divided property. What, you know, that's valid, right? That's in this particular case, or for financial relationships, that's who are in the middle of a divorce. Then, I mean, actually, this to me is much narrower than, of course, the 37-page HUD definition.
Sure. Oh, absolutely, absolutely. I mean, I am just looking at this. I am late to the conversation because of my absence earlier today. So, I mean, this is. I mean, I guess it's tighter than what I had when I was having my stream of thought because it does not include cousins, etc. I guess I'll stop and I'll just listen to the opinion of the others now.
I wanted to give you another example, which is much narrower, is over in Title 33 relating to benefits for human services. And in this case, it's, you know, much narrower. It's dependent children living with parents or somebody who's pregnant. I mean, there's no family members involved other than kids and parents. So I don't know that that's all that helpful, except it's just to demonstrate that how we describe family and family member varies by the context. And that's why I think you sort of have to decide, you know, how big you want your circle to be.
Representative Hango, then Triano.
Thank you. Thank you, David, for these two definitions. I am not in favor of limiting it to the definition of family that you just barely showed us. I think, especially during the pandemic, we've found a number of related people living with each other in households. And since this is related to the pandemic, I think we should go with the assumption that there could be people who are related to each other in these ways, living together in households, and the landlord who holds the title to that may not even be living with them, that holds the title to that property, but these are his or her family. So I would not want to limit it to the other definition of a traditional, what we think of as a traditional parents and children relationship. Thank you.
Representative Triano, then Murphy.
It seems like one is too narrow, one is too broad. You know, I'm just thinking aunt, uncle, niece, nephew. Niece and nephew probably would be appropriate. This is the same definition we used in paid family leave a couple of years ago. I remember it, but we did.
I think it was actually broader in that.
Well, we did. I think what we did is actually we limited it. We took some of the family members out of that definition on paid family leave. That's what I recall.
Oh, we built it out and then we trimmed it back. Yeah. Okay.
That good of that.
Yeah, it was that exercise. Nope. I recall. Yeah. Yeah.
So I don't know. It just seems to me that if a landlord wants a tenant out and says he's going to move Uncle Benny in, and uses that as a method for the eviction exemption, and then doesn't move Uncle Benny in, it seems to leave the door open for some maneuvers such as that. Whereas I think that immediate family does belong in this. So I'm somewhere in the middle. I think this is a little too broad, and the other definition was much too narrow.
All right, so I get that. But again, we're trying to narrow things down instead of leaving things out philosophically here. So yeah, let's just try to focus on what the solution to family is here, because we're saying the same thing. We don't want to be too narrow and we don't want to be too broad. So what's just right? And so David wrote down in the chat box, there's something from 414.
I just sent you the text of the language that's on your screen in case you wanted to see that. I also don't want to keep flipping around among definitions, but there are others. I just showed you a third one from Title 19 that is just literally two people living together. So how about, as the starting point, I suggest that you eliminate aunt, uncle, nephew, and niece. And we're just talking about children, siblings, parents, and grandparents.
Mm-hmm.
Is that better or worse?
I'm in favor.
I like it.
I think better.
And then we have a question of a sibling to the landlord. I mean, should it include a landlord's siblings or not?
I was going to offer that there is a definition that I found that says immediate family usually consists of parents, siblings, spouse, and children. And I think when we're speaking of immediate family, we're not speaking of family in the broader sense. And so I think we are, that would be my offer, which I think is in line, David, with what you're looking at. It would be parents, siblings, spouse, and children. So if you include parents and it's my house, that would in essence be potentially grandparents, but. And again, we could say such as or whatever. I mean, it's going to be a court determination. We just are giving someone the inclination to believe they could put a case before a judge.
I would find a place for siblings in there, I think, if we could.
So Barbara,
yeah, that was there. That was included. It was parents, siblings, spouse, and children.
Okay. Yeah.
All right, let's go.
I had parent and grandparent on my punch list.
Right, so they're included in this, right? Representative Kalaki, then Hengo.
If two people are living together, does that automatically mean they're spouses? Or do you have to be legally married to be a spouse? Because then that doesn't work. Right? So if, Tiff and I decided we were domestic partners and had been living together for 5 years, but we weren't legally married, would we be considered immediate family in this definition? I guess
again, I think if you're going to move into there together, then it doesn't matter because you already have the right as the landlord. If you're not, then that raises the issue of whether you want to include people who are separating or divorcing or whatever. Do you understand? Again, it's this concept of the person moving in having a relationship where they're going to live there without the landlord who would already have the right. So the question becomes, what person do you want the right to live there without the landlord?
So what What does spouse mean?
Well, I think the legal definition of spouse are people who are married or in a civil union in Vermont.
Okay. I thought that if you buy the property, the landlord has to, under existing pre-pandemic, cannot evict anyone unless they're going to live in the property themselves.
Before COVID,
Yeah.
you can evict anybody at any time pursuant to the terms of the lease and 9 VSA chapter 137.
But
You can have
it's a-
for cause, you can have no cause. There are different reasons of causation, and then there's just no cause at all.
Okay.
The differences that apply in those circumstances are not the legal authority to do so. It's just the amount of time that you have to afford the tenant for the termination of lease.
Are you set, Representative Kalaki?
Yeah, thank you, David.
Sure.
Thank you, Chair.
Representative Hango, then Plasek.
Thank you. I just wanted to say that there have been a lot of concerns mentioned, and I definitely hear all of them. I'm not sure that we should try to define this terminology, and I'm trying to come up in my head with something that would say something different than landlord or landlord's immediate family needs to reoccupy the rental premises. And I think maybe we should focus on that section that says landlord's immediate family and leave it up to the discretion of the landlord who their family is, because families are so diverse. I know people that are caring for their elderly aunt or uncle who have no home and have to live in the home. You know, a member of, it may not be the leaseholder, but a member of the family is caring for an older aunt or uncle. You know, that's just one example. Representative Kalaki came up with another example of two unmarried or non-civil union joined people living together, but they're in a committed relationship. So I'm not really sure we can define this. So I think we need to think of alternate language. Thank you.
Representative Plasek, then Triano.
Can we put that screen back up, please, just for a sec?
Which one, Mr. Chair, would you like me to show?
With that little definition that we just had up there, the family members. The shorter chopped down version definition.
This
Okay.
one?
That's fine, thank you. So, Representative Hango kind of stole my thunder on this one a little bit, but I was thinking this along the same things. I think we got to be a little careful here and maybe leave this a little bit more discretionary because there's just so many possibilities we can have. And just let me throw another one at you in an effort to prevent a domestic disturbance. I'll give you a scenario. I'll try to use a name. I don't believe we have any Jack Jones associated with anybody we've talked to. So Jack and his wife Sally Jones own a property. However, the rental property is solely in Jack's name. Now, Sally, I remember who it got, is his wife here. Sally's parents or whatever want to rent that property. So there's just another thing. If we use like a definition we have here, the in-laws, they're not in there. It's just there's just so many different things. I just throw that out there for food for thought. So I think maybe this might be a thing we don't want to don't want to get too particular on, and maybe leave it at the discretion of the board or the judge or whatever. Just my thoughts on it. Thank you.
Okay, Representative Triano, then Bloomley.
Include looks like some good language, but when we took testimony a few weeks ago, we heard from landlords that were either displaced or unable to move back into their homes. That testimony is what precipitated our need to make some changes in the language and add this section of the bill for the eviction moratorium. I'm thinking in terms of, we heard from people who couldn't move back into their own homes. Not that they were going to put their brother or their sister or their aunt or their uncle or their grandparents in that apartment, but they were unable to move into their home. That's what precipitated this movement. So, I think that, just opening it up to a broad interpretation can really defeat the moratorium more than we would like it to.
Representative Bloomley, then Hengo.
I would just second what Representative Troiano just said. I mean, I think that this is about extenuating circumstances that would supersede the moratorium. And I think that has to be narrow. And so one option would be simply to say the landlord. So that is, I guess, my suggestion.
All right, Representative Hengo.
Thank you. One last thought in response to Representative Troiano. Yes, that is what we heard in this committee. I agree. And what precipitated this. However, I don't know if anybody else has heard from other landlords than who we have heard from in this committee. And I've heard from a lot of them. And some of them are needing to help out family members who have kind of been forced to be down and out, so to speak, because of the pandemic and have no other place to live. And they have rental units and they would like their sibling or their aunt or, their kids to have a place, their adult kids to have a place to rent from them. So I would like to give them the discretion of being able to do that if they have a tenant that is not complying with the current legislation that landlords and tenants sign leases for. So that's where I'm coming from that, is that there are many more people than who we have taken testimony from in this committee that I'm thinking of. Thank you.
Representative Byron.
The share screen dropped down and I was watching David type may include. I think that could be a positive path to coming to an agreement on this, where we could use those maybe core 4 to 6 family nucleus identifiers, and with the may include, and that would allow the courts the nimbleness to maybe expand upon or look at it situation by situation. So I just wanted to offer that as a thought that would open up interpretation, but allow us to kind of have it defined at the same time.
And again, specifying, that this whole piece is just about an emergency for a very limited amount of time. Once this is over, I have one on one hand thing going with me, saying, well, we're limiting, and by limiting at all, we're going against fair housing law, this, that, and the other thing. But under an emergency purpose that this case would have to make, knowing full well that limitation would expire with the end of the moratorium. It's just how the thoughts are just tumbling out Representative Triano, then Walls.
So the way this is written, the landlord or landlord's immediate family as defined by an XXX needs to occupy the rental premise or. So what we're saying, or what the suggestion would be, is that if a landlord wants to move his brother into the apartment, he has the right to displace a legitimate leaseholding tenant in order to do that under this language. And that's just not right. That is not acceptable, to displace someone for no reason other than you want to put your brother in the apartment. And that's the way this would read if we expand this family member the way it's proposed.
Representative Walls.
Well, thank you. You, Mr. Chair, and Representative Bloomley and Representative Troiano have already said what I was going to say. My suggestion is, as you said, Chair, this is temporary. This might all be moot by August 31st. It's very possible. And so my suggestion is we limit the language to landlord, knowing that this is something that's going to be in effect in only for a few months. If we did leave in immediate family, then I would suggest we stop worrying about what that means and we let the court make that determination. Again, keeping in mind, this is very temporary. So I'd be in favor of either leaving in immediate and letting the court decide, or striking immediate and limiting it to the landlord. In both cases, knowing that's going to be law for only a couple of months.
Representative Kalaki, then Howard.
I think I would agree with Representative Bloomley's narrowness, and just for this emergency part we're talking about, just to say landlord.
Representative Howard.
Thank you, Mr. Chair. I would also be fine with that if you just say landlord or even landlord's family. I had a constituent that was asked to leave her apartment because the landlord's daughter was getting married, and she gave the tenant a year's notice. It wasn't it wasn't something really quick. Like I said, I would be in favor of either just landlord or just keeping it simple instead of inviting all these other relatives. Thank you.
So we have covered the waterfront with this discussion. What we have on the table, well, Representative Murphy.
I think that I was just doing what you were about to do. I was going to offer, see how many hands wanted to go with just leave it at family for this particular purpose of having the exemption to the moratorium eviction. I'm sorry, just to landlord. I'm not sure even what I said at this point, but just to the landlord.
So let's go with that as a choice. If there's a majority of of our committee members who will support that, then, so if you support just the landlord, limiting it for the duration of this conversation, I'm sorry, for the duration of the moratorium, to be landlord, then please raise your hand. Please use that and go. So 1, 2. All right, and those in favor of John, can you put your hand down, or I can do it? And those in favor of not in favor of only the landlord, please use this one. Okay, so the landlord only is the language that is the will of the committee on this. So I'm going to share screen. Sorry, I don't know what I'm doing here. I don't know why this isn't working. Hold on. Because it's the wrong page. So here we are in section E. And what we just voted on was to delete this. So committee, were there any other issues that had come up in this morning's conversation about this rental, this eviction moratorium? Representative Parsons?
Thanks. Yeah, I just was hoping that we could clarify sale of the property. It seems like Hilo said it's could be in G, I guess, already in there, but I mean, if we think that it's already in there, I just prefer clear language to the fact, and also in our language of sale of the property, we could also include saying, you'd have to have, signed that it's a sales agreement, not just going to sell it. So it'd be some more clarity there.
Would you be including, like, one of the issues with statewide housing law is that, and I may ask Jean or Wendy to weigh in on this if I don't get this quite right. First of all, I believe the sale of property is in G. Second, when you sell a property and you don't have other local ordinances that determine what the process should be, and the state doesn't really, it has some, but not as specific as, say, Burlington. And Wendy, I just thought if you could weigh in on, like, under normal circumstances in Burlington, the sale of a house what is the notice that a landlord would have to give to a tenant on the sale of a property?
I believe a landlord has to give 90 days notice, or if the tenant has lived there at least 2 years, 120 days notice. Is that correct, Jean? Is my recollection correct? And it's not just sale of a property, it's.
Yeah, that's the right numbers. In Burlington, that's a town ordinance that for any reason, less than 2 years, 90 days, more than 2 years, 120 days. Yeah, so that's the notice that has to be given, and it's not specific to sale of property, it's any reason.
And under Vermont law, you have to have a purchase and sale agreement, and you have to, at the time you give the notice, you have to have that in place.
So what you're saying, it doesn't apply to a purchase and sale agreement. It's what you're saying is that if the landlord decided, say in Representative Howard's scenario, that the landlord wanted their daughter to move into the apartment, they could give notice of eviction to someone 90 and 100, 2 years and under, it's 90 days. So, but in regular state law, there's what notice
30 days.
Um,
of a purchase and sale, or
Yeah, purchase and sale.
so while I think that personally, while I think that G covers someone's financial loss if they can't sell, I'm hesitant to simply say sale of property is the only reason, or another only reason to lift the moratorium and to make the case. So unless it included protections that were relevant to a pandemic. So I mean, what do other committee members think on adding the sale of a building? And again, I recognize that this was on the proposal done by the Vermont Landlord Association, and that it was not in the proposal for the Vermont Legal Aid in their proposal. And this is the conversation we're having to, find those compromises, because clearly this is language that didn't work for a lot of the language we're talking about here didn't work for one side or the other. And I just want to keep that in mind. Just because it was on the list doesn't necessarily give it any more level of priority than another, except to understand we're still operating.
Can I just throw a quick point in on that? This, irregardless of these two proposals, we're just, I'm advocating for constituents who have reached out to me, not either of these, Vermont Landlords Association or the Vermont Legal Aid. People have reached out to me. This was one of the concerns. So.
Okay, thank you. Representative Byron.
Well, isn't there a little bit of a correlation between what we're talking about with the sale of property and then the landlord property owner? Because if the property was purchased, the person would then become the landlord. And if the terms of the lease that was being passed to the new landlord were in place, or there were violations, you see what I'm saying? Because it's like under current law, they have to take over the existing lease anyway.
Yeah, certainly that part, that scenario is true. But there's other scenarios where it's, a 3 or 4 unit place, and somebody that purchases says, "Oh, this would be great, but I'd like to turn it into 2 large units." That's my purpose of it. And I realize this probably isn't going to affect all that many people, considering how close we are, and it's been brought up many times before that this would likely not be in effect for very long. But
I get what you're saying, but I think what you just finished there, when I started apologetically speaking over you, is kind of the point, right? Like, I mean, the way the tea leaves are falling right now, I think that we're only really operating under this for hopefully a couple of more months max, if that. So yeah, I mean, I think that's kind of where I'm at. Like, I totally get what you're saying, but if it's like a need to occupy for the property owner taking it over and there's no existing lease, harm, damage, et cetera, I'm struggling, just given that this is emergency order session law language, on the like, boy, I'd love to put a nicer bathroom in caveat. You know what I'm saying? So I guess that's where I'm at with this. I don't think like a desire to renovate, like necessarily, as long as the people are paying, right? So I don't know, I'll stop there.
Representative Murphy, then Hengo.
Thank you, Chair Stevens. I just was going to say that I too truly wanted to meet the need of the individual who had the signed purchase and sale agreement and wasn't able to complete that sale without the eviction. And I think that the language, as we change G to read, would be a situation where if your sale can't go forward, that is that harm that we're speaking of, and would hopefully grant you the ear of the judge to put your case forward. And that's all we're really looking at in this immediate relief emergency scenario piece. So I too have the concern of someone being able to make a sale complete, but I think that we've given an avenue for that in the emergency situation. So I'm comfortable with where we morph G2 if that's what has been accepted by the committee, because we never actually agreed to the or and to the property. I think the property got added, but the or really changed that sentence, and I'm hoping that everyone is willing to let it be that. Thank you.
Representative Hengo.
Thank you. I too have been approached by people who have this sale agreement that they cannot complete the sale, but for the tenants who are there. So I do not share the confidence that Representative Murphy has that G is going to cover that scenario. So again, this is about people who have reached out to me, and it has, in my mind, nothing to do with just willy-nilly wanting to get rid of somebody, get rid of a tenant, but to follow through on an eviction that may have been started a long time ago, the process, and stayed, or perhaps something new that's arisen. And the tenants, again, I will reiterate what I said before that maybe people didn't hear, is that the tenants may not be complying with the terms of their lease in whatever way, shape, or form. And some of that could be that they are not paying their rent and have not paid their rent for the last 12 months. So that's where I'm coming from on that. So I would agree with Representative Parsons that this is one of the considerations that I'd like to see. It seems like we're moving really far in one direction away from the other direction instead of trying to come together in the middle. Thank you.
Okay. So again, we are at a point where I think Representative Kalaki.
Representative Parsons, could you literally show me this, the sentence and the words you might suggest? So I'm having a hard time understanding the concrete nature of your concern. So I'd love to see the
that's a fair
language.
question. And I don't know if I have it.
Well, maybe if
Perfectly
the chair could share his screen again for the language we're working on, and then you show us which letter you're interested in changing, and maybe we can see if we can wordsmith it. It'll help.
Well, before I even go there, I would actually just before we start wordsmithing a choice, I think the concept is, do we want to add a section on, as it's being proposed, before we even get to knowing what the straight details are, or not? I mean, that's where we are. If we vote yes, then we'll have to wordsmith something.
Okay, I need for Rep. Parsons to restate his concern so I can then know if I'm in favor or opposed to it. Because I'm not clear what he wants to do. That's all.
Yeah. No, I'm just thinking of language that would basically, but for not being able to remove the tenants, that being the reason that a sale with a purchase and sales agreement wouldn't go through. I don't know the exact wording, how it would work. I wouldn't certainly wouldn't propose anything that where it's just very broadly the sale, or, you know, you don't need a sales agreement and everything like that, but I've certainly heard stories, and I'm sure we all have, certainly did because I was in committee, where that literally was the one thing holding up somebody being able to sell their property. I mean, there's nothing else holding me up selling anything else that I own. This was the one thing where during this moratorium, we said you can't remove these people from the property.
Okay.
That's the one thing holding up the sale.
Okay, thank you. I think I would say that I agree with your point, but I think it's already covered in our current language. So thank you for restating it. I'm sorry I got a little lost there, but I would say I think the current language actually covers your concern. So that's I think that's what Representative Murphy said a little bit earlier as well. I'm not sure. I don't mean to quote you, but anyway, that's where I am now.
Representative Bloomley.
Yeah, after, in thinking about it, I feel that G is a pretty broad statement, and and it's just the kind of situation that would cover what Representative Parsons is talking about. Immediate or irreparable injury, loss, or damage to the applicant. So in this context, in the terms of exceptions to an eviction moratorium, this is the language that I'm comfortable with.
All right, so we're at a point, I think, where I guess the question would be, those in favor of adding language about sale directly, those in favor of adding language that refers directly to sale of property in the manner that Representative Parsons described it, please raise your hand or do your checks.
Representative Troiano, you have had a hanging yes for quite a while. I just wanted to let you know.
And those opposed to adding language that refer directly to sale, please raise your hand. Check your box. Okay, well, that's clear. Thank you, everybody. This is this is hard, but thorough. Representative Murphy.
I just wondered, Chair, I know I've spoken of it a couple of times, but could we actually do again a straw poll, a check and an X or whatever on the G language? So we know that we've confirmed and then have something to be done with.
Did we not get a straw poll on the G language? No, because we got technical difficulties. Yes, so looking at G, which reads no other immediate or irreparable injury, loss or damage to the property, the applicant or other residents. Those in favor of that language, please check yes or raise your hand.
I'm sorry, I need to see it. Is it somewhere that I can read?
It's what the chair has, so maybe he could repost it.
Thank you.
Let me know when we're ready to vote.
I'm fine.
Representative Walz. Wait, I didn't, wait a minute, let everything clear. I wasn't. All right, all of those in favor of the language in G, please check your box, yes or no. I'm sorry, it's yes first.
My yes is not working, so I'm raising my hand.
Okay. And anyone who is opposed to G being used as the language, please. Okay, then that's fine, or that's the vote on this. And I said that's fine, and I want to just acknowledge that I know some of this language is not accepted by everybody, you know, in its whole or in its parts, but perhaps in its whole. Did we have any further questions on this language? Representative Plasek.
Not a question specifically, but are we going to get a clean copy of all any changes for tomorrow morning? If we're going back to this tomorrow, I haven't looked at the agenda yet.
Yes, we're gonna, the S79 is what we've worked on thus far, has been sent to the proofreaders and the editors, and so those sections through the revolving loan fund are already have already been edited and cleaned up. So whatever language we decide either today or before we finish the bill has to be added to that. And then, yes, we would be given a clean copy of the bill.
But that's before the final vote, right?
Yes.
Okay, thank you.
Representative Murphy.
Thank you, Chair Stevens. I just, again, may be jumping the gun, but would offer that we do still want to speak of the home share exemption. And I don't know if a simple resolution on that, if we're in agreement of wishing to provide it, to tag it somehow onto the farm housing, which we're exempting with a sunset. And it just gives time for it to be reviewed and figured out how to include it so that you still are providing safe housing for people.
So I will say you're jumping the gun by one step in the process. So let me focus on finishing this eviction moratorium and then we'll go right to that, because I think everybody needs to see the language, and I think it will fit into our day if we can. I mean, we're booked solid tomorrow morning with housing related stuff. The floor looks pretty shallow in terms of time. And so I would assume that we would have enough time to do a final review of that language and get a clean copy before the end of the day tomorrow. So the proposal has been on this for quite some time to add it as a section to S79. All those in favor of adding the language that was up on the screen that reflected the work that we did on this? All those in favor of adding this as a section to the existing text of S79, please signify positively. Okay, and those opposed adding this language as a section? Everybody's not off yet, sorry. Everybody who's opposed to adding this section as the eviction moratorium section in S79, please raise your hand. Okay, the ayes have it. So David, this is I don't know what the proper section is, but if you could add this as a section to, I'm going to send you the text that we've been working on, and then I believe it's a no-brainer. I hope it's a no-brainer to say that the effective date of this would be upon passage, right? Not July 1st. Okay. So David, I will provide you with that in a moment here. So let me see. Everybody can go back to our website. We reposted the material from Wendy Morgan on our website. That was from last week. That was a representative of the rehab board on the language that was being suggested for the home shares. And I just want to see if I can bring it up, or you guys can bring it up on your own.
Do you know what date that's under, Mr.?
It's
there
on
today. It's today.
there. It's on today's.
Thank you.
It's the top of page 2. So if Sarah or Wendy wants to chime in on the reasoning that the Rental Housing Advisory Board was making the suggestion, I would appreciate it. You know, mute. Yeah, there you go.
Sure. To be blunt, it was an oversight on our part. We didn't really think about it. Many of you are familiar with Home Share Vermont. It's been a very successful program in the Champlain Valley in Washington County. It matches people through a very prescribed program to share homes, and often involving an older person. It was called to our attention by the director of that program that they have, under other pieces of state law, had some exemption. And the committee agreed that that made sense. As we looked at what has been done in other law, there's also an exemption if you're providing an apartment to a caregiver, and that seemed very reasonable. So we adopted that, and then we hadn't thought about immediate family, which you've just had a big discussion on. But the point being, if you have a rental space or a space in your home and your son or daughter is living there, or we didn't, unless these are offered to the public, for another time in the year, we did not intend to include them. So these were just simply oversights on our part. They were not really in our original thinking, and when called to our attention, we wanted to provide the exemption for them. So it's three groups. Those operating under a prescribed home share program, those providing personal care to an occupant in a household, and immediate family members. And we're suggesting those units not be registered and not pay a fee unless during another time in the year they're open. So for instance, if you have an apartment and your son comes home for 6 months and stays there, that's fine. But if then you turn around and rent it to the public, you would still register. But if your son occupies it for the whole year, you probably wouldn't. Wendy and I, having sons who live with us, adult sons, so we should disclose that. So again, it was an oversight. I don't know if you've got any questions on it.
Representative Palacic.
Yeah, just, I guess I got it. Just real quick on what you just said, Ms. Carpenter. If you had, say, some family member who is living with you and helps you pay room and board, so to speak. Well, board, I guess it's not my situation, but I guess board means food and stuff like that. But room would be, helping you pay the rent type thing. Is that considered this, or is that exempt?
I think we were considering it exempt. So if you have a family member living with you and they're paying you some rent, ordinarily that would be a rental situation, but we're suggesting an exemption for that. unless you turn around and rent it to the public.
Right, and I understand there. Okay, just curious, it came up. It doesn't apply, so I just wasn't sure. But thank you.
The paying rent thing for the grown child at home is a hot
You
button.
got one of those too?
A hot button issue this quarter in our house. So, but he bakes a fabulous bread. Representative Hango.
Yes, thank you. I am almost hesitant to ask this question, but what about the terminology immediate family member, since Sarah brought that up? What do
Well, I did listen to your previous discussion. I think we were not quite as pondering about it. And I think it's a little different circumstance. I think we were trying to suggest that if you don't go and, you know, put a notice on Craigslist and it's intended to be family. I mean, in this case, you know, we were suggesting that it could be exempt. There are lots of definitions, as David pointed out. We didn't define it. We could. We just felt like our intent was not to discourage property owners from allowing family in the units. But we didn't have any deep discussion on the definition.
Okay, thank you, because I really am concerned about the person that I mentioned who's caring for her 91-year-old uncle in her home, and another person who has a developmentally delayed child who is no longer a child, who is an adult living in their home.
Well, caregivers were also suggesting an exemption for it.
Yes,
So
yes.
that would be all, and they would not, there doesn't need even to be a relationship there. So
Right, so a family member would be okay in those situations.
yes.
Okay, yeah, I guess I didn't mean to say child, because that's definitely immediate family, but you know, or niece, or say it was a developmentally delayed niece who needed to live with them, because
our intent is if it's a caregiving relationship,
okay,
that they be exempt. I mean, that's our intent. That.
And is that in here? Because I know that home share agreements aren't always about providing care. They are.
It
Well,
says
that
right
would
here.
be
No, it says in this language that it's providing personal care to a member of the household.
Right, but home share isn't always that. It could just be two adults who choose to live together for whatever reason because they can't afford to live alone, correct?
Right. It's really, there's 3 exemptions, not 2. There's home share, and the home share is not every home share, but if it's an arranged program, that's one exemption. There's a caregiving relationship. That's a second exemption. And then the third exemption would be your immediate family. So there's 3 different situations covered.
Okay, thank you.
And David, if you can just, if I can put you on the spot, and if you can chime in on this, if you can, on homestead tax, that this was based on a section of law that already exists.
We were pointed to that by the director of Home Share Vermont. It's a little bit different. That law has to do with how you define a household for purposes of taxes. And actually the exemption under the homestead law includes family members. But as we started thinking about it for the purposes of the registry and our purposes, we felt we should include family members, not exclude them. The income sensitivity only speaks to home share and personal care relationships. So we actually added that in. We put that note there just for you to understand that there is exemption in other parts of law, particularly for the home share and caregiving kind of thing.
Okay, committee, what's your pleasure on this? Do we want to sleep on this and deal with it tomorrow?
I wondered if David could just respond to the connection to the statute.
Sure.
I'm not sure what the question is. Is it the same statute? What exactly are you asking?
I guess the first question I had was how, Sarah answered quite a bit of this, that it was based on the homestead tax sensitivity section that defines households in home shares, but she then proceeded to say that they just use that as a basis of a starting point. So I'm not sure, Barbara, what what question you may have directly for David.
I'm sorry, I was tagging off of yours and just wondering if he had examined it with that statute language to offer anything on it.
I mean, it's accurate. It is based on the definition in 6061 subdivision 3, the definition of household. I mean, if you're going to move in the direction that you're discussing, then I mean the construct would be a little bit different, and we'd have to create another exemption in that subsection C right after the farm employee housing, and you would say, you know, it also doesn't apply to the following 3 categories, you know, to the extent the unit is not offered to the public. And then we would have 1, 2, and 3. We'd have the people who are related. We'd have providing services, and then the home sharing agreement language from 6061. So it'd be very comparable. I don't know that it would be identical.
Thank you.
Sure.
So do we want David to work on this and then present it to us tomorrow?
I would appreciate that. Thank you. I think that what he presented verbally sounds very much like what we're asking for. And if we could just see it in print, we might be ready to go.
I agree.
I still remain uncomfortable in kind of and I don't mean this to inflammatory, but it's such a heteronormative frame of family. And I just don't know, immediate family makes me uncomfortable. But there's lots of constellations of what family means. And, you know, certainly during the AIDS crisis, people brought people into their homes, and that's a caregiving thing, I understand. But I'm just, I think if we could find a different phrase for that you welcome in your affiliated people into your home, is fine. I don't have a problem with that. I think the rest of this is great. I think this is an exemption. If Barbara invited a neighbor to come live with them in their home there, and that was appropriate, that's fine with me. I don't think it has to be her children or her siblings, or I mean her. So
can I offer Representative Kalaki that I think that the piece that says, and it'll in the new writing as David presented it, would actually be the header, that it's not available to the general public. I think that's the critical, so that then it is, I mean, then you are left to define your immediate family, because I certainly have dear friends that are closer than some family. And I think that is that piece. I think it's very different from the exemptions in the moratorium that we were looking at, where we wanted it to go before a judge and really be determined upon. This is where if your extra room isn't available to the general public, that's the critical line, I think.
But if you invited your dear friend in to rent that extra room in your house, that would be allowed as long as you didn't rent it to the general public?
That would be my reading, because I would call them my family member, but I might have to defend that if some Snoopy drawers decided they wanted to get into it, or saw me put an ad in the paper to look for a dear friend.
And that's just my discomfort right there. That's the
I
only thing.
appreciate that.
Yeah.
Sarah?
Well, just, I mean, we were trying, you know, there's existing landlord tenant law now. And so there are lots of circumstances where you may choose to rent to a friend or an acquaintance, and you're still subject to landlord tenant law, and you're still subject to health and safety. So, you know, I think we would argue that if you're subject to landlord tenant law and health and safety, you know, you probably should register. It is a gray area. And so I think it you know, if I were choosing not to register, and I don't think this is as critical as an eviction moratorium, you'd have to argue the relationship. You know, did I tell all my friends, I have a room for rent for $500, and somebody you know pops up and says, I'll rent that room for $500. To me, that's a rental relationship. You know, if your niece or your longtime acquaintance comes and says, I'm desperate, and you say, sure, you can stay in my back room, and it's not a rental contract, you know, and there, you know, I guess you'd need a lawyer to argue the difference, but I think that's sort of the intent that, so it isn't that you wouldn't rent it to somebody you know, it's, do you have a rental contract? And if you have a rental contract, you probably should register it. If it's not a rental contract.
Well, then if your son and Wendy's son is paying rent, that's renting. And if Tom Stevens has his son pay rent, that's renting.
It is, and we're just proposing exempting that. I mean, we didn't do it before, and
right. But I'm saying you're allowing that to happen in that family construct and not allowing it to happen in my family construct. And that's the only difference I have.
I'm not trying to pick relationships. I'm only saying is the one to my son wasn't offered to the public. So if your friend is not offered to the public, that's the distinction you'd have to make. And I don't have a rental agreement with my son. So
no, I didn't mean to personalize it that way.
No. But I'm trying to
really
distinguish.
Apologize about that.
It's sort of that, would you fall under landlord tenant law or not?
Well, we're talking about exemptions here. So, and family members is my concern I bring to the committee.
And I would say Representative Murphy's construct of not offered to the general public is probably another way to look at it, because that is our intent. If you look at health and safety landlord tenant law as a consumer protection law, and actually the whole S79, or at least has been offered as consumer protection. So that's kind of the construct.
And again, I apologize.
No.
Representative Troiano.
Worked with a constituent a few years back who were an 80-year-old couple who had their son move in with them to help care for them. And he was a working guy. And when they called me, they were adding his $30,000 a year income to their household income because he was not paying any rent. And so that you know, causes a predicament as well. And when I consulted a tax preparer that I know, his suggestion was that, you know, have him pay $25 a week rent, and that then he would be, his income would not count against the family's income, because these poor folks lost their income sensitivity down to almost zero. You know, and an 80-year-old couple living on a fixed income, that was, you know, that was a bad situation. I tried to fix it through a bill that went to Ways and Means and died on the wall. So, you know, I think there's a reason that some people will rent to a family member, and that would be it, or at least one of them.
Representative Plasek.
Thank you. And just real quickly, Ms. Carpenter, I'm glad you guys are working on this. I mean, I've had dozens and dozens of emails and some calls on this bill and the rental registry in itself. And I can't imagine, I can't give you an honest account right now. I have to go back and do it. It'd take me hours and hours to give you an answer. But there's so many of the residents or constituents that have contacted me that are concerned that with this new rental registry issue that, you know, they're not going to be able to rent to their relative or their close friend and everything. And I, you know, I'll be glad when this is finalized. Hang on a second. Yeah, I'll be down in a minute, buddy. I'm sorry, my grandson, he's been over here for an hour for me. Anyway, he did that the other night, by the way, too. Lost my train of thought. Oh, they're all very, very concerned, and some of them are up in arms. Some of them, how dare you support a bill like this? And some of them, I beg you not to do this. But it's a big concern with the contingency right now. For clarification on this, and this is something I'm very happy to hear you say that you guys are trying to address this issue, and I think this clarification needs to be put out to the public sooner than later. Thank you.
Thank you. So I'm going to stop here. I would like to just ask David, we've worked a long time, and I would like to have David do the rewrite of this and share it with us. You know, maybe David, you can send it to Ron and Ron can distribute it at some point, whether it's tonight or tomorrow. It's no rush. I mean, tomorrow morning we were back here for, we're going to take testimony tomorrow morning on the budget proposal. There was a letter from the working group, the emergency housing working group, about how to spend the ARPA money, and that was shared with the appropriations committees. And so we're going to get a rundown of that. And I think we already shared it, or if we haven't, we will make sure it's on the website. And that's just talking about what's going on with the budget and the proposal of how to spend the ARPA money and what's in front of us. We haven't heard anything from them for a little while. And then we're going to follow that at 10:30 with a Housing 101 that I've scheduled a couple of weeks ago now. And this goes into our category of listening tours of stuff that we maybe should have heard in January, but it's language and vocabulary and concepts in affordable housing that we've learned as we've been going. And so the presentation is from folks who will bring it go back to having it in an introductory way, so that as we start to hear about how this money is going to get spent over the next several years on housing, that we understand the vocabulary that we're talking about here. I expected to be done with 79 by now, so I didn't feel like there was a problem scheduling that at that time. Tomorrow after the floor is a time when we will wrap up this work. I'm hoping, David, if you can insert the eviction moratorium with the effective date being upon passage. And if you can, that leaves us just with this. I think I'm going to bypass the language on VHCB at this point in time. I'm just concerned about timing and talking more about other changes, and I'm satisfied with the work that we've done on the elements that we've gotten done so far. We'll address those other elements as time allows this biennium. So David, does that make sense to you?
It does. Can I just ask, do you guys want the same, sort of sunset construct for these exemptions that you have for housing provided as a benefit of farm employment, or do you want them to just be permanent for now?
I think the intent was to keep them permanent.
Okay, got it.
And again, if there's finer points to discuss, and John, to your concerns, we'll discuss them with a little bit more rest in our bodies, and see if let's just sleep on what we've done and deal with it with fresh eyes tomorrow. Representative Hango.
Thank you. Is our committee still going to be at 9:15 tomorrow?
9 a.m.
9, okay. somewhere I was getting 9:15. Thank you. So we'll have a clean copy of this entire bill sometime tomorrow morning.
I would suspect that what we'll have is, I guess that's a mostly yes. I mean, because if David, depending on how we just ask now, if we just ask David to, we've agreed on everything so far in some fashion up to this language here. And so, you know, David, if David could provide us with a clean copy of everything that we have, I don't know, tell me, do you want to see this language put into the clean copy so that we don't have to go back and forth again?
Yes, please, with the eviction moratorium language, with everything that we've discussed, and this would sort of be up in the air when we.
So yes, David, if you can include this language, and then we'll, I don't know, highlight it, and then when we get to it tomorrow, this is all we have to consider for tomorrow afternoon. And then depending on what changes we make, if any, then we can flip this, you can just re-edit it and get it done to us, back to us by, you know, whatever it takes to re-edit it.
Thank you.
No problem.
David, thank you for your work today. Jean and Wendy and Sarah, thank you for being in the room today. I know it's a lot of time. Committee, thank you for working through to this point. And